I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today it's going to be number 89 in our compilation series. We're going to be jumping into 3 different judges' courtrooms. Actually, the first case that we're going to show you is actually a recent case, but I'm adding it to this compilation. It just happened in one of the courtrooms, and I'm going to give you the name of that judge in a second. Also, just want to let you know that there will be no commentary at the end of this, and that there will be chapters added for your convenience. Like I said, the first proceeding is a new proceeding, and the other 2 are throwback proceedings that we've shared here on the channel. Now, first courtroom we will be in will be that of Judge Simpson out of the state of Michigan. Second, we will be in the courtroom of Judge Tammi Hayward out of the state of Georgia. And last but not least, we will be in the courtroom of Judge Erane Washington out of the state of Michigan. You guys have been enjoying these compilations. And let me say this. I truly do appreciate you guys showing me love for the work that I'm putting in on the compilations, the regular proceedings. Thank you, because it definitely takes a lot of work, especially when you're still working another job and doing this at the same time. So I appreciate you guys appreciating me. And now let's go ahead and jump into number 89.
Courthouse case, People versus Joshua Wara.
Government vote for the people.
Mr. LeBeau's case. Wara.
Joshua. Thank you, Your Honor. Mr. Warren, can you state your name, sir?
My name is Joshua William Worrell. I'm representing myself in this case.
So you don't want to be represented by an attorney?
No.
Okay. All right. Well, I would say there come some perils with you representing yourself. You understand that, sir?
No. I know
You
the
don't
mission.
understand?
I'm a jailhouse
Pardon?
lawyer. I know what I'm doing. You are working.
I'm sorry?
You are being paid by Adolf Mack to fry me. This is conspiracy for murder. Your wife, Delphia Simpson, came up here pretending to be Ann Arbor Comprehensive Care Center yesterday. You are originally the Tux family. You are an Egyptian lord. You're Illuminati. If you do not help me,
I'm Illuminati?
I will sue you and criminally prosecute to the fullest extent.
Okay, I welcome that. You're invited
Thank
to
you,
do so.
Cedric Simpson.
What do you want to do with your case today?
Ellen Wara, Adolf Mack, Jeffrey Peak, Cynthia Miller, Frank Stanton tried to set me up, along with Derek Miller and Ryan Miller.
Okay, but I've got to do something. I've got to do something with your case.
Huh?
I've got to do something with your case. What do you want me to do?
I would like to sue. And what am I in court for today? And I would like to prosecute to the fullest extent.
Okay, so
And
let
I
me
can
do
sue
this.
for 10 times the amount of what was stolen from me. They stole $666.8 million from me. They then turned it into 5.5 trillion and then put a hit out on me. I legally can sue for 10 times that amount, which would be $550 trillion. And I can criminally prosecute to the fullest
I'm with you.
extent, which is
I'm
my
with you.
right.
I did the math too. Listen, here's the thing. I have to advise you, because if you are going to represent yourself, what you're here on, okay?
I'm doing it over Zoom.
So you're here on a complaint that alleges that on October 15, 2025 on South Main Street
the Pentagon's
in the
using
city of
prisms
Ann
to make
Arbor,
the
Washington
Zoom,
County,
mess up.
that you failed to stop at the scene of an accident regarding resulting in serious impairment or death. Do you understand that charge?
$1 trillion.
Yeah, sure. And that's a felony, punishable by up to 5 years incarceration, a $5,000 fine plus court costs.
which is actually 10 times the amount because I can sue because it's conspiracy to murder. And sovereign law would make it 100 times the amount, but since it is conspiracy to murder, sovereign
I'm
law
with
does
you.
not
I
exist.
got you. I just have to let you know what you're
Which
charged
means
with.
I can sue for
There's
1,000
also a
times the
count
amount.
2 on the complaint that
Legally.
alleges that on that same date and at that same time, that you did commit a moving violation causing serious impairment of a bodily function. That's a misdemeanor punishable by up to 93 days, $500 fine plus court costs. You understand that?
Yes.
Okay. So there are serious perils representing yourself as opposed to having counsel. I would just have to advise you, you'd be treated the same. You are charged with making sure that you have an understanding and that you abide by the Michigan rules of that you abide by the rules of evidence and the rules of procedure. You understand that?
Yes, Cedric Simpson.
All right. And the other thing that I have to advise you of is that at any point during these proceedings, you wish to have counsel.
No, I do
all
not
you
want
have to
any
do
counsel,
is
and I
just
want a bench
listen-
trial,
listen
not
to
a
what
jury
I'm
trial.
saying.
Because a bench
And
trial
then
is
if at
backed
any
on
point you do,
an objective evidence.
if
A
at
bench
any
trial
point
is
you
objective
do
evidence.
want counsel, you just have to let the court know and the court will make sure that you have counsel.
No,
You
I do not
understand
want
that?
counsel.
Okay. So what do you want me to do with your case today?
I
Now
would like
that
to
I've
do a
gotten through
bench
that
trial
part.
because a bench trial is on subjective
bench
evidence
trial?
and a jury
Well,
trial can
that's not
be
gonna happen.
bribed. And they're trying to
Okay,
bribe the
you
jury.
can go to
So
circuit
I
court and
want
have a
to
bench trial.
prosecute with sovereign law and it's conspiracy to murder and Donald Trump and Elon Musk are involved and I can sue for 1,000 times the amount. And sovereignty
Your Honor,
does
if I
not
can
exist
if I
because the
can
amount of money that
I
they
don't know,
put
I've
that
not
hit
been
out
very
on
good at
me,
it, but
and Donald Trump and Elon
oh,
Musk and Adolf
so-
Mack and Doug Minkoff and Jeffrey Peak and Ellen Wara all have estates that and residencies in states that do apply the death penalty. I would like to get
okay, I'm with you. I got you. Let me hear from somebody else real quick.
Your Honor, if I was working with Mr. LeBeau on this file, I was going to be asking for an adjournment as this is a new file. The defendant is on surveillance video at the intersection of this crash causing this accident and then fleeing the scene. That has not been provided to either the defendant or his attorney if he has
I'd like
one.
to get
So we would
Donald
need
Trump
more
to
time. The defendant's on parole, and if he's entertaining the idea of representing himself, I think it's important that we refer him to competency first.
Well, I don't know that I can do that right this second, although maybe. But here's what I'm gonna do. Sir,
Cedric Simpson.
I'm gonna adjourn your
I do
case
not want a
out.
jury trial. You cannot adjourn this. This is a high profile case. Where I can't.
Okay, but you
There
haven't
are too
seen
many
the
people involved.
You
You have a
haven't
Neuralink
seen.
in your brain and you are being manipulated and bribed and conspired against for murder by the Nazis. You will work with me.
Alrighty then. So you don't want an adjournment?
No, I do not want an adjournment. I want a bench trial.
Okay, so
It's based on
listen,
factual evidence. The jury trial can be bribed.
I hear you. So the only thing that can happen is I can set this for a preliminary examination, but you haven't seen all the evidence.
I don't need all the evidence. I know all the evidence. Let me get a discovery
Okay, then.
packet though, so I can represent
So-
myself though, please. With all evidence, I would like to.
You want to
subpoena
represent
phone records
yourself?
and all evidence.
All right, listen. Okay.
I would like to
So you want this
subpoena
set for
Bill
preliminary
Warren's.
examination?
I would like to subpoena Bill Wara. I would like to subpoena Scott Casey, the Michigan militia, all of their phones, Doug Minkoff, Jeffrey Peak, Adolf Mack, Donald
We're not
Trump,
bringing all those people
Elon
down.
Musk.
Yeah, okay. If you want to subpoena them, then you can. But I'm not bringing all those folks. My problem is he's asked for his exam. So I will have to set it. I wonder who'd like to hear this.
Your Honor, would we still be on the case?
Hang on, I'll get to that in a minute.
Thank you, Your Honor.
So I'm going to indicate he doesn't want his discovery. Says he doesn't need it. Man. I'm not gonna have the complaint that's rights have been infringed, so yes, I'm gonna do it. And you're gonna be mad. It's okay.
You don't care about my feelings.
I don't care about your feelings because you don't care about mine. But we shouldn't air this in public. No, I have to do the, no, I can't. I cannot. Sorry, I have to do it. I got you.
Okay.
I hear you, but I can't do that. So here's what I'm gonna do. I'm gonna set this for defendant invoking what he has. Would prosecutor have their witnesses available the 28th?
Yes, sir.
Sir, I'm
Yes.
going to give you your preliminary examination. So your preliminary
you.
examination will be set in person on.
Your Honor, I'm so used to just
And,
saying, yes, sir.
Adolf
No, I
Hitler is
know,
in
but
the
I
judicial
realize it's
court
close. But
with Carol
it-
Conkey in East Hope, et cetera, et cetera.
excuse me?
Carol Conkey is involved. She is at 22nd Judicial Circuit Court with Feiger and Ellen Warren and Jeffrey Peake. Elon Musk is with Trump at the Michigan Supreme Court in Lansing. I do not want to adjourn. I want a bench trial now.
I am not adjourning. I'm giving you the quickest preliminary examination I possibly can.
Yes, sir.
But I have to hear from all sides regarding that. I would set it for the 28th. Counsel, most of these witnesses are police witnesses, so we could at least begin.
Okay, thank you. What's today?
That's a yes or no.
Yes, sir.
What
Thank
is
you.
Today, what is today, Cedric Simpson?
Pardon?
What is today, Cedric Simpson?
Today is the 23rd.
Okay, Miss Lee, I'm sorry that I'm executing your husband.
You're executing what?
Miss Lee's husband, who is Adolf Mack. I'm giving him the electric chair. And I'm
Fine.
suing him for everything he owns. He's JP Chase Morgan. He owns Chase Bank. I want Chase Bank. He's Hitler.
Okay. All right.
I'm suing for Chase Bank and giving JP Morgan Chase, who is Adolf Mack, the electric chair.
Okay,
If
thank
Elon
you.
Musk works with me.
Okay, so here's what I'm going to
And
do.
Donald Trump.
I don't know that we'll be able to go given how you're
Yes,
acting.
we will.
but
I want
I'm
a
gonna
bench
set
trial
your
today.
preliminary examination.
I am sorry, Cedric Simpson, that the and Adolf Mack, JP Morgan.
I'm going to set your preliminary examination for October 28th, 2025, 9 a.m. That will be before me. I'm not, if I let the PD off, because I may on my own motion be referring for competency, I will do it that day. But so right now, to answer your question, Mr. LeBeau, you are still on the case. Because I think the more the merrier.
Thank you, Your Honor.
You're welcome.
I-
No, you're not really thanking me, but I get it.
it.
All right, thank you. Thank you, sir.
The next case is LaTanya Denise Turner versus Brian K. Widener, State of Georgia, Salah Holdings, Delphine Gresham, and Larry W. Johnson. All right, is there Ms. Turner, LaTanya Denise Turner?
Yes, I'm the attorney, in fact, on behalf of the principal, who is the resident agent. I have also already submitted forms appointing the judge over this matter to administrate on behalf of the principal. And I also submitted the rest of my entries on records. Now, with that being said, the Form
Ms. Turner,
56
Ms. Turner.
appointing judge.
Ms. Turner, I gotta see you first.
Okay. I'm trying to, there I go.
Okay, there you are. All right, so
Okay.
Ms. Turner, very quickly. I've reviewed the information that you provided. First of all, you're suing with respect to a foreclosure, which is a situation that involves land and a determination of ownership with respect to land. That is not my jurisdiction. I'm in state court. State court does not have jurisdiction over determinations of land. We deal with dispossessories, which is a temporary situation with respect to land, the allowing someone to use your land in exchange for rent or your property in exchange for rent. But we do not deal with the whether a foreclosure is proper. So in this case, this court is going to have to transfer your case to the Superior Court of Clayton County, depending on whether this is Clayton County that's involved. And so I see you're suing the state of Georgia. Not sure how they're involved. Not sure how any of these parties are really have an interest in this case. But with respect to the jurisdiction with for foreclosures, that is not what I do. Okay. All right. Is there anyone else here on behalf of any of the other parties who either disagree with what I've said or who have anything that they would like to put on the record?
So, Your Honor, this is Larry Johnson. I represent Brian Widener as well as myself. I just want to point out to the court, this was initially filed and I was not named.
Okay.
And after I filed an answer on behalf of Mr. Widener, the plaintiff just stuck my name and added it to it without a court order. And at that point in time, she needed a court order. So I'm not personally, I mean, I'm only in this case because I filed an answer for Mr. Widener.
Intended to name me too. So Ms. Turner, I know you have a set of beliefs about how the law works, but the way we do it here is just because somebody files on behalf of another person, everybody's entitled to have an attorney represent them. And so you can't then sue the attorney for giving them a defense. So everybody who comes into the case doesn't get sued individually. Like there are people who are responsible allegedly for what you are contending happened, but then there are other people who they choose to hire to help them navigate the case. For the people who are navigating the case and for the judges who are dealing with the case, you don't get to sue them because they don't have an interest in at that level. They're just trying to help the other person navigate the case, okay?
Could I get finished recording my interest on record?
No, ma'am. You've done that. You're the plaintiff.
Okay. Well, Judge, I would like to record my interest on record.
I'm not sure what that means, ma'am.
I'm the attorney of fact on behalf of the principal, who is the registered agent. I already submitted the Form 56 upon you over the matter to administration on behalf of our principal.
Ms. Turner, nobody gets to appoint me over the case. I'm already appointed to whatever's assigned to me through the clerk's office.
I appointed you through my for my trustee. And Your Honor, I would like to add also to the case and ask you a question.
No, ma'am.
Yes or no?
The question that I'm not going to answer any questions because this is not my jurisdiction. I'm going to transfer the case to Superior Court and let them sort it out because land use and land and interest in land is under the jurisdiction of the Superior Court. Okay, so we'll get you an order. We'll also dismiss Mr. Larry Johnson from the case pending whatever the Superior Court decides because he's only here to represent the defendant, which the defendant has a right to hire an attorney to represent them, and that attorney doesn't deserve to be sued because they are helping somebody defend themselves.
This case is also in the federal court also.
Okay, then if it's in federal court, then it probably doesn't need to be here also. You shouldn't have a case running in two different courts at the same time. Okay, that's just going to cause confusion. And you're not going to achieve what it is you wish to achieve.
Okay, Your Honor, I know this court has no jurisdiction per 12 CFR 1500. And also, is there or should there be an investment in private residential property in the United States? Or is deposit?
That is a question bigger than any of us can handle. People can invest in whatever they spend their money on. So at this point, I think that you're going a little bit too far afield. Like I said, we're going to go ahead and transfer this case to Superior Court, and my brother or sister judges on Superior Court will help you sort out what it is going on. Okay. All righty. So we'll go ahead and get an answer out to all of you. get an order out to all of you, transferring this case to Superior Court. But just as an aside, Miss Turner, everybody who comes in as a representative of somebody else, if they're an attorney, don't sue them, because it just makes the case harder to get through. Okay, if you want to achieve something with respect to finding out what happened with your foreclosure, don't keep adding people to the
Your Honor, in this executive branch of law, I have a right to sue the attorney, anyone else
Okay,
involved.
Miss Turner,
In this executive branch, I do have a
Ms.
right to
Turner,
sue them and
everything
anyone
you
else
say
involved.
is nonsense. None of what you're saying makes sense. None of what, Ms. Turner,
It's
trust me.
federal law.
Ms.
It's
Turner,
federal law.
Ms. Turner, we're not in federal court. None of what you're saying makes sense. You haven't established an estate. There's no trustee. You're giving us word salad. You're just saying stuff that you've read or somebody told you was appropriate. It's essentially called a sovereign citizen, but
no, it's not a sovereign. It's not. I'm not a sovereign citizen.
If those things
No,
work,
that
ma'am,
don't put
everybody would
don't
use
put that
those.
on me. I'm not a sovereign
Ms.
citizen.
Turner, you've made statements that sovereigns use, and so
I have my trust set up, and
Okay.
I'm not a sovereign citizen.
Yes, ma'am.
I am a person working in my trust.
Okay, if
Not
you
a sovereign citizen.
all right,
That's
Mr.
against the law.
Okay,
I'm not a sovereign citizen. So I have my trust set up
okay,
in a way that it's working for me, and I have it set up.
okay.
And that's what I'm working on, my trust.
Good afternoon. The 14B District Court is now in session. My name is Erane Washington, and I'm the judge that will be presiding over this session. The court will call the matter of the Ranches of Rosebrook versus Anise Battle, case number 25C-1245.
Good afternoon, Your Honor. David Fantera on behalf of the plaintiff.
Ms. Battle, could you please state your name? I'm sorry, could you repeat that?
My name is Denise Battle.
Thank you so much, Ms. Battle. All right, today's day and time scheduled for a hearing in this matter. This is an action to terminate the tenancy based on non-payment of rent.
Yes, Your Honor. I object to these proceedings moving forward because, like I said, I do have a verified petition and emergency motion for injunction in the U.S. District Court, which is the case number 25-CV-11233.
Thank you, Ms. Battle.
And like I said, this court has not put on the record their jurisdiction. There's nothing on the record, and it stands. Every notice that I've sent is unrebutted, which stands at law. And jurisdiction is a threshold issue that we shouldn't even made it this far without discussing proper jurisdiction.
All right. Anything else, Ms. Battle?
As of right now, no.
Okay, thank you.
But I object to these proceedings in jurisdiction, subject matter and personal.
All right, your objection is noted for the record. Ms. Battle, I've already ruled on jurisdiction when we were here last time. We will be proceeding today. The court does have jurisdiction. Mr. Fantera, and Ms. Battle, do either of you have...
I object. The court cannot declare its own jurisdiction to respond to.
If you keep interrupting me, ma'am, you're going to get held in contempt of court, and the court does have contempt powers while you're in jail.
I interrupted you. Okay, that's all.
Your Honor, I want to point out also that Judge Vandenberg actually addressed this issue last Wednesday and said that the 14B District Court and Your Honor does have jurisdiction over this matter. So not that it needed to.
May I add, Your Honor? Yeah. She also said that she was not aware of the things going on. So she just went on for anything based on what he just said. To shed any law nor facts, just as you don't, of why you have jurisdiction. And it's no order that has it back yet, to be clear.
All right, thank you. Again, Ms. Battle, this court has jurisdiction and we will be proceeding today. Mr. Fantera, if you well, actually, the both of you have an opportunity at this time to do any opening argument that you want to make. So, Mr. Fantera, I will start with you. Do you have an opening statement?
I'll waive my opening statement, Your Honor, and just get right to the evidence.
All right. With respect to service, can you please put on the proofs regarding the service in case there is an appeal?
Say that again, Your Honor.
Can you please put on proofs regarding service in the event that there is an appeal?
Mean service of this lawsuit?
Yes, on Ms. Battle.
I believe that she was served by a court officer with Jimmy Moore's office, Your Honor. I think there's a proof of service in the file. I don't know whether it was attached or whether it was personally served. But the court has that proof of service.
With respect to proof of service, the file indicates that Ms. Battle was served with two different ways pursuant to MCR 4.201B, which is she was served, actually three different ways. She was served with an original mailing from the court, and then a second mailing went out from the court. Second mailing was requested by the plaintiff and was sent by this court. On March 28th, there was a mailing. And then there was service by Edward Cope, who's the court officer. That service was effectuated through securing an attachment to the main entrance of the tenant's dwelling unit. And that was done on April 4th, 2025. And after attempts had been made on April 2nd at 12:40, and then April 3rd at 9:53, they finally did an attachment on April 4th at 4:30 p.m. In addition to that, Ms. Battle showed up to the court on April 9th, 2025 before the magistrate, therefore acknowledging that she had received service in this matter and that service had been perfected. Right. With respect to jurisdiction, we addressed that at the last court hearing. This is in Russell Court, which is within the jurisdiction of Ypsilanti Township. I think we hung up.
Your Honor, when she comes back, can we require her she appeared the last two times with a video. Can we require her to have video today?
Ms. Battle, are you back?
Yeah, we were disconnected.
Yes, Ms. Battle, you're back. All right,
Yeah.
what request were you making, Mr. Fantera?
I know the last two times that Ms. Battle has appeared, she appeared with a video, and this time she's just on her phone. Can we require her to be here by video today also?
I would have had to give
Well,
her.
the thing is like I tried to tell you all last time that the time was bad. This is when I pick up my kids.
All
So
right,
if we can do it like earlier or something of that nature, yeah, that's fine.
Then I'm okay just proceeding as long as the court is comfortable that we can swear her in when she goes to testify.
Thank you. I am comfortable. I can tell you that if I was going to require that she be here via video, I would need to give her notice of that prior to today's date. So I'm comfortable proceeding as we are.
Okay.
All right. And Ms. Battle, that jurisdiction which has been noted and reserved. Do you have any other argument you want to make today with respect to this matter in terms of an opening argument?
Of course. So, like I said, the contract has been rescinded on April 1st, and it was due to unconscionable pieces in the contract, including pieces that's wrong with the formation, as well as material breaches that's inside the contract. That contract has not been.
You said
material breaches.
Oh, okay, go ahead.
Breaches, yes, within the contract as well. That was sent out and received. Well, it actually wasn't received on April 1st because at the end of the day, the unconscionable pieces, their addresses are wrong and the owners are wrong on the contract, so it got sent back. But once I realized it was received on April 8th, 2015, and still remains unrebutted. They have yet to unrebut it in any case that we came and talked about the contract. And by law, according to Wall versus Zendaya, the Michigan law recognizes rescissions at common law for breach, fraud, and unconscionability. Meaning, if I give notice and it's unrebutted, that stands at law. Also, I've talked on personal matter jurisdiction, in which why I came in under special appearance the first two hearings, because at the end of the day, I'm not a legal person. I'm not in a legal capacity under Michigan law. I do not qualify as that person, which that person is a corporation, a trust, individual, and some type of legal entity of that nature, an association. I do not qualify as one of those people to be here and subjected to this without consent. Hence why, things were sent administratively and defaults were given administratively, because things are happening right here where I'm being deprived of due process, and I should be awarded due process by law. As the attorney stated last time we were here, he was saying that basically the burden of proof only applies in criminal cases, which is false, because the burden of proof applies in all civil cases where jurisdiction or contract validity challenged, and that's Taylor versus Bullam in 1992 in Michigan. You still have the burden of proof. The court cannot establish their own jurisdiction being based on a contract is rescinded. You have to have a valid contract to come into court about. So that's where your jurisdiction of the subject matter is at hand, because the contract is rescinded, not unilaterally, like he tried to claim before. It is rescinded, meaning I gave you notice and it's unrebutted, just as if somebody came into the courtroom for an eviction, or if they did not come for the eviction, you'll give them a default, because what happens at law, your silence stands.
All right, thank you, Ms. Battle. Mr. Fantera, you may proceed with your case.
Plaintiff would like to call Dawn Charles as a witness.
All right, Ms. Charles, please raise your right hand to be sworn. You swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing.
I do.
Thank you. You may lower your hand. You may proceed.
Ms. Charles, please state your name for the record.
Dawn Charles.
And what is your position with the Ranches of Rosebrook?
I'm the property manager.
Are you familiar with the tenancy of Anise Battle?
I am.
Are you familiar with the lease agreement that she signed?
I am.
Your Honor, I submitted to the court a lease agreement dated November 12, 2024. I'd be moving for that to be admitted as Plaintiff's Exhibit 1.
Did you also provide a copy to the defendant?
I did not, because I do not have her email address. But she should, Your Honor, I should say for the record, she should have a copy of the lease, because it is, because she signed it.
Any objection?
I never received a hard copy of the lease, and I've asked for a hard copy of the lease. never received it, and as I read the lease, that was also a breach of my lease, as I was supposed to receive it and sign it in person, as they made me sign it over online. So again, the information that he's saying about the lease is correct. I'm not here to argue about the lease as far as what the original contract was. I'm arguing about the validity of what it is now, which is invalid and void because it's been rescinded.
Thank you.
And unrebutted.
All right, given that she's not arguing about the validity of the lease itself, I will allow the exhibit.
No, I said I did argue about the validity of the lease as far as it being valid, because it's not. But I'm not arguing that I entered into a lease on or around December 6th. That's not what I'm arguing. I'm arguing the validity of the lease. So let's correct that.
You're not arguing that you entered into the, what are you arguing?
Like I said, I do not object to actually entering into a lease. What I thought was, yes, a proper lease on or around December 6th. I do not deny that, but I do deny the validity of the lease because the lease has been rescinded and it's unconscionable. Yes.
Thank you. Her argument, as the objection in the case is that the lease is rescinded and therefore it's not allowed to be admitted. That is overruled and it will be admitted.
Oh, 1 second. Y'all gotta. Everybody be quiet. I'm sorry, I didn't hear you, Judge.
I said that your argument that the lease is rescinded is not being admitted. The lease is admitted. That objection is overruled.
On what facts of law?
The fact that I just ruled that, ma'am.
That's not a fact or a law. So let the record show that he has no proof.
The record
no
shows
law or no
everything. The record shows everything, ma'am. You didn't need to say that. And please stop.
I know it will when I pull the transcripts, because like I said, this case is also.
All right, Mr. Fanteri, you may proceed.
Okay, I want the record to show that I find it unfair that you can cut me off and use my mic whenever you feel like it. But I can't talk and have a fair hearing.
You're going to be held in contempt of court and you're going to do jail time. Mr. Fantera, please proceed.
Ms. Charles, can you, under the terms of the lease, what is Ms. Battle's monthly rent?
$1,075.
$1,075?
Correct.
Does she also have to pay utilities?
Water and sewer.
So for what months has she not paid her rent?
March, April, and now May.
So she owes $1,075 for each of those 3 months.
Correct.
Has she, does she owe the water and sewer for those 3 months also?
Yes.
How much does she owe for those months?
Her water and sewer?
Yes.
So March is $36.24.
April?
$35.45.
May?
$35.73.
Okay. That totals $107.42, correct?
Correct.
Are there late fees under her lease?
There are.
What is the late fee?
$50.
On what day?
The 6th.
And so she's being charged a late fee for March and April, correct?
Correct.
So the total amount that she owes is $3,225 in rent, $107.42 in utilities, which is also rent, $100 in late fees, and then she would owe the court costs of this in this matter, correct?
Correct.
Have you reviewed the work orders that have been submitted by Ms. Battle since she has been a tenant?
Yes, I have.
Are you comfortable that they were all completed in a timely fashion?
Yes.
No further questions, Your Honor.
Thank you. Ms. Battle, do you have questions for Ms. Charles?
Yes, I do. So the first working order, are you able to disclose, or do you know firsthand what that was?
Your first work order was your shower water wasn't hot. You had some screws in your hinges that weren't secure. And when the water was turned on in the tub, it comes out of the shower as well.
Okay. So how do you define complete? How is that work order complete?
Well, that was the work order you put in. The notes for repair are that the diverter for your hot water was repaired. Our construction company fixed the tub faucet that had came off, and we installed new screws in hinges on the door.
Right. So do you have anything that the actual construction company came, because nobody came? Because even if you go on to the next 3 orders, that's also listed as an issue because it was never addressed.
Well, the next work order after that was actually December 26th, and it says the door that was repaired, the screws were still not right, so we put new screws in it, so that wasn't a work order about the tub. The one after that was January 28th, and that was about hearing animals in the attic, and we installed new soffit and made sure nothing was in there. There was also one on January 27th. We adjusted your shower head and plunged your toilet and tightened a basket on your sink. There was one on February 14th that your tub was not draining and water was coming out of the faucet. We unclogged the tub and the shower head was working properly. And the last one was March 17th that your furnace was cutting on and off. And we took your furnace apart and checked all the fuses and put it back together, and it was up and operating properly.
Okay, so let's go into that more, because we might even have to subpoena the maintenance man, because this is going to become an issue. So when you say that you came into my bathroom and screwed the shower head, what would be your purpose of doing that? Because what was my request? My request is that it was still, the water was still coming out of both faucets at the same time, which have not been correct because you have not gotten a contractor out here. A contractor has not came out to my house about that. And let's go on to the heat, right?
Miss Battle.
I'm sorry.
You can't testify now. You can ask her questions. You will get a chance.
Okay, I'm gonna ask her
Contractor was
You're
in
right.
the apartment between December 15th and 16th because
Wait a second. Wait, everybody stop.
Wait.
There's no question.
You said I had to form it as a question. I apologize.
Okay, go ahead, Miss Battle.
Okay, so you're saying that a contractor came out, you said December 16th?
Correct.
And what contractor was that? The contractor that did the job?
Correct.
Okay, and when that contractor came out, what did they say that they did?
Repaired the tub faucet that had came off and repaired the tub diverter.
They repaired the what that came off?
The faucet for the tub.
One more time.
And the diverter for the water.
Right, okay, so let that address that the faucet pushing out and the diverter, that doesn't address the issue of the plumbing, which really, when I had somebody come out, they said the wall has to be taken down because what happened is they messed up behind it. So again, let's rephrase, let's go on to the new one. Let's go on to the furnace. So when they came out for the furnace and they came out to fix it the first time, what were their results from that?
I only have one work order for your furnace. They took it apart, checked the fuse, put it back together, and it was up and running. They cleaned it and put it back together.
Okay.
The furnace is new.
So no, it was 2 work orders. One was done in the middle of the night. Early in the morning before they came into work.
Your Honor.
So I just wanted to be clear, so you don't have that work order for the morning? I'm asking the question.
1 second, there's an objection.
Your Honor,
Oh, you said it was an objection?
Can you please listen to it, Ms. Battle?
I can hear him now. You say he had an objection?
Your Honor, I want to object. We're getting into the weeds here. I mean, you don't have a right to withhold rent or rescind a lease because of something small such as a tub faucet. And so, you know, we're getting into whether somebody actually came out and fixed it or when it got fixed. And it just seems to me that this is irrelevant to the proceeding that's going on today.
Well, it's object because it's not irrelevant to the proceeding because it's part of the reason on why I put up the brief. Because at the end of the day, I kept trying to get somebody to come out to fix these things that are not fixed. Heat is a major thing. It's been cold. I still have a heater in my house because they haven't came back and got it and fixed it like they said they were going to. You know what I'm saying? It's still unconscionable things in the lease regardless. So everything about what I am arguing here is valid because I do have the right to rescind the contract based on breaches of the contract, just like you can come here on a quote unquote breach of the contract. It's the same thing. Why do I not get the same right and to hear what's going on so she can hear what's going on?
Your Honor, we will be more than happy. The purpose of rescission, as the court knows, is to put the parties back in the same position they were before the contract got entered into. We will be more than happy to rescind this contract and basically have Miss Battle pay what she owes through the date of move out and terminate it so she doesn't have any more rent owing after move out. The problem is what she said to Judge Vandenberg last week, and I believe what she believes, is that when something gets rescinded, she is allowed to live there until she finds a new place. And that is not the law. We are more than happy to rescind this, to do away with this contract, let her pay her balance through the date of move out and terminate this contract so that she can move on and we can move on. But what we can't let her do is to live there forever without paying rent.
Well, let it show that by law, by contract law, if the breach is on your end, if you want to comply to it, like I said, because I did rescind it, and the breach was on your end, and it's rebutted on your end. And by law, under the landlord and tenant, it is called constructive possession. When you are in breach of a contract and I'm not at fault, I am allowed under equity and law to stay in a place. It's called constructive possession. Constructive possession. The breach is not on my end. It was on your end.
Miss Battle, that's not the law, ma'am. That is not the law. Absolutely not at all. And ma'am.
Okay, so then if that's the case, if he wants to call out the breach of contract, then he's making it an uneven deal. Okay? So if he wants to say that he wants to accept the breach, then he has to accept the damages that come behind it. Because there's damages if I have to relocate on something that's not based on me. That's unfair. And that is that's unfair in bad faith.
Your Honor, I'm not trying to be unfair. All I'm trying to say
is the breach is not on me. The breach isn't on me. So if the breach is on me, I will understand what you're saying completely. The breach is not on me, so I should not be held liable for y'all breach.
Yeah, but you're the one that wants to, Your Honor, but she is the one that wants to rescind. So it seems to me that she can't have.
I want to rescind based on the unconscionable contract. And what does my rescission also say? If it says it, if that's the case, if you all want me to leave and you don't want me to have the constructive possession, then you ought to be paying for my relocation because it was your injury to me.
Can I say something without being interrupted, please?
I want you both to stop talking for a minute, please.
Go ahead. I'm sorry.
So, first of all, if you want to talk about whether a contract can be rescinded, that is not typically what happens in a landlord-tenant. That's in a standard contract situation. However, if there is, in fact, a situation where capital is for you to get some of your monies back. That's not something where you get to just rescind the contract. That's why all of this is the wrong procedure. However, Mr.
I'm sorry.
Please. Mr.
You
Fantera.
were saying something about getting your money. I need you to go back a little bit. It's breaking up really, really bad.
So you're
Because I can't hear you clearly.
if in fact the court were to find that, for instance, the property was not habitable, like there were enough repairs that were done so that the property was habitable, we're not going to be able to make this out. The children in the back, my recorder is saying she can't make it out.
I'm trying to make it out too, and it's just like breaking up a little bit. Just I tried to tell y'all that this was not like a good time for me at all. Remember, you had got his time, and when I went to go pay my time, you cut my mic off, and I was literally trying to tell you that I cannot. It's 3 o'clock. Is just not a good time. I'm getting my kids out of school. I don't have help when it comes to getting my kids out of school. So, yeah, but we can continue to try. We can just try to go for a morning time. I can do morning time.
I have on the morning. You have to figure this out. And if you don't figure it out, then the repercussions will be against you. You're gonna have to figure it out.
Well, hold on. I am trying to figure it out. I wouldn't be here if I wasn't trying to figure it out, or if I wasn't trying to,
I grant you that. I agree with that. I agree with that. But I have criminal documents every morning. We don't morning docket.
You said what about a warning? Hey, stop. Hey. You said what about a warning?
I said we have criminal dockets in the morning, ma'am. Is what I said.
Yeah, I can do it in the morning.
That's not what I said.
Oh, I'm sorry. I'm sorry.
Hold on.
Hello? Y'all can't be that loud. No, Leah, for real.
Mr. Fantera, this is not working. It can't be recorded properly because of the background noise. I can't finish this today. Are you available on the 16th at 9 in the morning?
I am, make sure my witnesses are Dawn.
Yep.
Ms. Battle, are you available at 9 in the morning on February 16th?
May 16th, Your Honor.
May 16th. I'm sorry, I'm discombobulated.
Yes, 9
a.m. works?
Yes, 9 a.m. is perfect.
16th at 9. We'll be back here again.
Your Honor, can we require, since I asked before and you said you didn't give notice, her to be by video Zoom?
Yes, Ms. Battle, can you come via video Zoom, please? Ms. Battle, you're muted.
I'm sorry. I keep trying to mute it because I think that's why I keep muting me because of my background. But I say yes, that's fine.
Okay, thank you. I appreciate it.
And I will also mail copies of all of the exhibits that I submitted to the court to Ms. Battle so that she has them beforehand.
Thank you. We'll see you all.
I appreciate it, David.
See you all May 16th at 9 a.m.
Okay. Thank you.
I'm not threatening you. Say one more word and that's 30 days. 30 days.